today we'll get to July. Good morning, this is Senate Judiciary. This is Wednesday, May 1st, 2024, also known as May Day in some circles. And we have a number of rules to walk through today as we approach the end of this committee's regular work for the year. So I'm going to turn it over to Michelle Childs to walk through an act relating to parentage. And please.
Sure. Good morning. So we're taking a look at H 745 as passed by the House. Everybody was here in 2018, right? All of y'all were here? No, you weren't here yet.
Yeah.
Okay.
I was in the House.
You were in the House.
2018.
And you were here. So,
Oh, no, I was not in the House.
No.
No, that was 2020.
Okay.
So no.
All right. Well,
My goodness, 2020 going here.
I was elected to the House in 2020.
I was here in 2020.
Anyway,
all right. Well, I was
I
just
was
trying
here.
to, I know you were.
You were here.
And I know Bob, were you on? No, you weren't. Okay. All right.
I came in when Tanya came in.
You know, these
Okay.
three are fast risers.
I know. It feels
I mean,
like
they
y'all have
already-
been here forever.
They hardly, they put a foot in the house and realized it wasn't where they wanted to be.
It's true. Well, I just mentioned that because in 2018, the legislature passed the Vermont Parentage Act, which is like its own Title 15C now. Prior to that, Vermont really just had all of these really very antiquated parentage laws. And as you can imagine, thinking about it in the context of 2018, what today's families look like compared to, you know, decades prior to that, when those laws were enacted. And senators, you might remember, Justice Dooley was getting ready to retire, and he came before the Judiciary committees, or he might have just done this when he presented in the House because it was a House bill initially. And he said, "I have one thing to ask before I go. Can y'all please update these laws, because the judiciary is really trying to, you know, respond to all these various family situations and recognition of parentage, but we're using these antiquated laws that really don't reflect the way that families are formed currently." And so in 2018, the legislature passed a comprehensive Vermont Parentage Act that would better reflect the way that families are formed currently. And worked with a lot of stakeholders, worked really closely with the Office of Child Support, and Susan Murray, who you might remember, who was an attorney who practiced family law for years and was very helpful, as well as
Part of the Brigham decision.
Baker.
Baker.
Yeah, along with Beth Robinson.
One of the plaintiffs in the.
Yep, one of the attorneys for the plaintiffs. And so there were a lot of practitioners involved in crafting it, looking at the Uniform Act, as well as Maine, and bringing in different parts of that. And the point was to recognize that there's many ways that a person can be declared a legal parent. And when we're talking about all of this stuff today, and we're talking about parentage, we're talking about the establishment of a person as a legal parent. We're not talking about parental rights and responsibilities. So we're not talking about things like care, you know, like child custody and those types of things. The rights is a separate issue. We're just talking about, according to the law, are you a legal parent? And there's lots of ways that you can be identified as a legal parent. It could be through giving birth, through adoption. There could be a marital presumption. So like if the child is born during the course of a marriage, it could be by signing what's called a voluntary acknowledgement of parentage. It could be admitting to parentage in a court action. Could be what's called being a de facto parent. de facto parent, there's certain criteria under that. It could, but I think the most common one would be thinking of, if you had mom who's living with her lifetime partner, and that partner is in the household with her children from a previous relationship, and her partner is raising the children with her and acting as a parent. It could be being a genetic parent, or it could be consenting to assisted reproduction or a gestational carrier agreement. So there's lots of different ways to become a legal parent. Also, what you want to keep in mind as we go through this is that there can be more than two parents. So I think we, tend to think of it as this, well, there's just, mom and dad, but there could be, it could be many ways where you could have, like I said, you could have the two genetic parents plus the de facto parent who is in the household with one of the parents helping raise the child. It could be, so there's lots of variations. So don't think of it as that there's only a maximum of two legal parents, because the goal of a lot of this is to provide stability for children and to arguably three parents could be better than two. When the legislature adopted this in 2018, because it was such a kind of more holistic change, everybody kind of thought, well, we'll come back and look at it in a few years after it's been operating and just see what kind of tweaks need to be done. What kind of maybe little snags have practitioners run into. And so that's what this bill is before you. So I'm going to go rather quickly because I know time is short, and the two witnesses that you have on today have been really so helpful to me because they're practitioners in this area. So it's Jess Seaman from OCS and Polly Crozier from GLAD. So I may, during some of this, if you have a question, I may need to phone a friend. But I'm going to start, and I'm going to go quickly, but we'll revisit it. And I also have a summary from kind of the House proposal as well. So section 1 is the definition section. There's only one small change in there, but I think it's helpful to have the definitions up front if you need to go back and take a look at them. The one change is on page 3. The definition of gamete is just changed, so it just means a sperm or egg. Section 2.
Are you on? I'm sorry. You're on page 3 where? What line or?
I think of the underlying bill she's doing.
Oh, what is this? I got draft 1.1.
Do you have the right
As
bill?
passed the House.
As passed the House?
Let me get on board here. As passed by the House.
Yes,
There we
you
go.
also have an amendment for me because Senator Sears asked me to add, there were pieces in the miscellaneous that were just technical changes to some old statutes and Senator Sears asked me that I just put them into this other amendment. So I'll go over that in a moment. So the change to gamete is on the top of page 3. Section 2 on parentage proceedings is, you'll see that on page 6 in subsection E, if you're involved in a parentage action, you're supposed to provide your social security number, and there's just a small addition there to say, like, if the person has one. So if the person is here, maybe they're a legal resident, but they were not born in this country and they don't have a social security number, they wouldn't have to provide that. Section 3 is on adjudicating competing claims of parentage. And this section addresses how the court must use a best interest of the child standard when there are competing claims of parentage. Now, this is in statute, this is in Title 15C. It is a different set of circumstances on evaluating best interest of the child in a parentage proceeding, and that's different from if you were going to use the best interest standard for parental rights and responsibility around care and custody in Title 15. And the amendment says that a court can include consideration of evidence of pre-birth intent to parent the child in making the determination. So an example of this would be if a lesbian couple chooses to have a child with a family friend who is donating sperm. There's two possible parents to the child in addition to the person who gave birth to the child, right? So it's the partner of the woman who gave birth to the child and the person who has donated the sperm. So if the parties agreed that they all intend to parent that child, then the court can consider that and find that the child has three legal parents if it's in the best interest of the child.
Michelle, quick question.
Yep.
I'm wondering, why isn't this already covered under lines 8 and 9, where it says other equitable factors arising from the disruption of the relationship and so on?
I don't know. I mean, maybe you can make an argument under that, but I think that, these were recommendations from the practitioners about just clarifying. I don't know whether or not the witnesses, maybe OCS or somebody had kind of bumped into something.
Okay. Yeah, it's not that I'm opposed to it. I just know that sometimes when you start getting specific about what you can bring in, then there can sometimes create a presumption that there's other things that you can't bring in.
Right.
So,
But I think in this is just saying that the court can consider, what kind of evidence prior to the birth of the child, can be brought in to determine whether or not there was an intent to be a legal parent.
thank you.
So section 4, this is challenge to a presumed parent. So this section addresses when a person can challenge the legal notion that someone is a presumed parent under the law. So what's a presumed parent? So the current law provides that someone's a presumed parent of a child if one of 4 situations exists. 1, the person is married to the birth parent at the time of the birth. Second one is if the person was married to the birth parent at the time of conception. Third is that the person married the birth parent after the child was born and is named on the birth certificate. Or the person resided in the same household with the child for the first 2 years of the child's life, and the person and another parent of the child openly held out the child to be that person's child. So that's under current law. So the language that you have in section 4 in B1 is intended to address the ability of either a birth parent or a presumed parent to challenge a presumption after the 2-year period, because the default is that you can't challenge the status of a presumed parent after 2 years. Again, you're trying to kind of get certainty for the child, but there are exceptions in B. And so you can go outside of that 2-year time limit when the presumed parent is not a genetic parent, never resided with the child, and never held out the child as the presumed parent's child. So our current law doesn't grant standing to a birth parent to challenge a presumption of parentage after that 2-year time limit. So let me give you an example. So OCS explained that they had a case where there was a married couple. They divorced. The wife, shortly after, had a child with another man. And the ex-husband knew about the child, but was not the genetic parent, never resided with the child, never held out the child as his child. However, because the child was conceived before the divorce was final, the ex-husband was presumed to be the legal parent of that child, even though, the birth mother and her new partner were parenting the child and treating that child as their own. They were the genetic parents, but because she was still married to her ex-husband and the divorce wasn't final, when the child was conceived, then there was a legal presumption. So this new language allows that mom to challenge and so that ex-husband, who is no involvement at all, either as a genetic parent or in parenting that child, would not be a legal parent. That makes sense? So, looking at subdivision B3, that allows a person withstanding to challenge a presumption if the child has more than one presumed parent. And subsection C clarifies that if there are two presumed parents in addition to the birth parent, the court should adjudicate parentage based on the best interests of the child. Section 5, this section sets forth the process when there's only one presumed parent in addition to the person who gave birth to the child. And you'll see at the top of page 10, it sets forth those circumstances. It's if no party to the proceeding challenges the presumed parentage of the child, then the court adjudicates them a presumed parent. 2 is that if the presumed parent is identified as a genetic parent, and then that's not challenged, the court adjudicates the presumed parent to be a parent of the child. And 3 is if the presumed parent is not identified as a genetic parent, and the presumed parent of another presumed parent or another party challenges that parentage, the court just goes back to that best interest of the child standard. So section 6, bottom of page 10, this makes some changes to de facto parentage, makes a small technical change to the standards for adjudicating someone as a de facto parent. So remember that de facto parent is someone who's cared for the child and holds the child out as their own child, but may not otherwise be legally recognized as a parent. So again, kind of thinking as the life partner of one of the genetic parents. So current law in this section sets forth the standard for adjudicating someone a de facto parent in subsection A. And the amendment to subsection B simply refers the court back to the standard of best interest of the child if there's competing claims around parentage, and clarifies that a child can have more than one parent.
Doesn't a child by definition have to have more than one parent? You can't make a child with only one.
Right. But I think the thing is that there's this whole menu of things.
Okay. Wait a minute. Okay.
So section 7 is consent to assisted reproduction. And so in here currently it's required to be in writing. And so this tweaks it so that a person can show their intent to become a parent either through a written record or an oral agreement between the parties, because sometimes folks don't get it down in a contract or in writing. Section 8 is just a technical change because I used some gendered terms in there on line 12 on page 13. So that's just a technical amendment. Section 9, this amendment's intended to allow a person who's filed for divorce to proceed with assisted reproductive technology 60 days after filing for divorce. And in that case, both parties to the marriage will only be considered parents if they agree to in writing after the commencement of the divorce. And so this is essentially to address a situation where, sometimes divorces can take some time and can drag on for years. And so if someone has, wants to proceed with assisted reproductive technology and conceiving a child, they would be able to go ahead and do that even though they filed for divorce, but the divorce isn't final. And so that person who is not going through ART, they would not be considered a parent unless they agree to in writing that they want to be a parent of the child that is conceived through reproductive technology. So section 10, let's see.
Oh, no.
So section 10 This section addresses when birth and parentage orders are issued when a child is born through the use of assisted reproductive technology, and says that if parentage is uncontested and everyone is in agreement to who the parents are, then the court shall issue the parentage order promptly. So basically, if everybody's in agreement and there's no challenges, then they are to issue the parentage order. Section 11 is on eligibility to enter a gestational carrier agreement. And so you see the changes on page 17.
I'm sorry.
Surrogacy.
I misunderstood the word.
Gestational.
Yes.
And so this section addresses conditions under which someone can enter a gestational carrier agreement, otherwise known as a surrogacy agreement. And subsection A requires that a person who intends to be a carrier has a medical evaluation that includes a mental health consultation. And subsection B currently requires people who are the intended parents to complete a medical evaluation and a mental health consultation. And what the House did is replace that requirement with a psychosocial education and counseling related to the gestational carrier agreement. And that seemed to more clearly reflect the intent of ensuring that the intended parents understand the conditions of entering into such an agreement. But this language, you'll see that on B is what we're talking about, is having to do with the people who are intending to be the parents, not the surrogate. So on section 12, this is addresses a scenario if a gestational carrier is a known family member. So currently, if genetic testing indicates that a genetic connection between the surrogate and the child indicates a genetic connection. It says currently, if genetic testing indicates a genetic connection between the carrier and the child, then the court is supposed to determine parentage. And the amendment here is to address situations where sometimes it may be a family member who's going to be the surrogate. So it may be someone's sister who says that they will carry the child. And so that's just to kind of accommodate that potential scenario. And then section 13 on birth and parentage orders with respect to using a gestational carrier, and just says that if the parentage is uncontested and everybody's in agreement to who the parents are, the court is to issue the order promptly. And then the effective date would be July 1st of this year.
So does this bill, I'm thinking of Alabama and the recent court ruling that got down there about embryos. Is there anything in this bill that?
Unrelated.
That's totally unrelated.
Mm-hmm.
Okay.
Yeah, this is about this legal determination of who is the parent of the child after the child is born.
And after the child is born.
Mm-hmm.
Okay.
My understanding too is the reproductive rights constitutional amendment would protect from a ruling like what happened in
Well, but
Alabama.
that hasn't passed yet.
Yes.
Mm-hmm.
Was it voted on by the people?
Yeah, in November.
Why did I miss that?
Because you got a lot going on. You got a lot
There's
going
a
on.
lot going
Senator Sears.
on.
I guess so. Yeah, you're right.
It was a long process.
Yeah, it was. Yes, you're right.
And you had an awful lot going on.
Yeah.
Right. So I'm going to take you, and I know I'm going through this so fast, but I think that the witnesses will be helpful, and then I can always circle back with questions. But I did want to go through the amendment that I have for you as well, and that's dated April 22nd. The first instance of amendment is just something that practitioners kind of thought of after the House bill had passed, and that is just amending the law on surrogacy agreements, that if it substantially complies, then it's enforceable. And that's just so that if there's some kind of little small technical error or something like that, you wouldn't want necessarily the whole surrogacy agreement to fail. And then the rest of the amendments were requested by Office of Child Support, and it's really just some cleanup language. So what you have in the second instance of amendment, so section 13A, and you can see this is kind of an example looking at some of these older laws that are still there that we did not repeal. So that amendment to section 293 assumes that there's only going to be 2 parents for child support purposes, because it refers to either parent. There might be more parents, and so we need to recognize that in the law to reflect the changes in the Vermont Parentage Act. And then there's just some minor little amendments to bring it in line with that. And then there's also some references there to old laws that we repealed in the prior act. And so we've just updated that. Section 13B is repeal of the statute, and I've probably mentioned the statute before in prior years when we've worked on child support, but there is a statute called Man in the House that is still on the books.
So what?
Man in the House.
A man in the house.
Man in the House. And so you'll see the language that's being, it doesn't reproduce it there, but I'll read it to you, is that under current law, when the mother of minor children is residing within the same household as a man unrelated to her and not otherwise liable for the support of the mother and her children, on complaint of the mother, or if she's receiving public assistance from, OCS would file a motion, then they would make an order with respect to that man in the house. And so this is obviously antiquated. We've addressed these issues in other ways. It's no longer in practice at the Office of Child Support. And the issue is really around establishing parentage.
So how old is this law?
I don't know. I can look when I have a second. When you go to the, yeah, I'll take a look when you go to the witnesses.
There's some antiquated stuff on our books that
Yeah.
it still exists that we don't use anymore. This is certainly a surprise.
Right.
It's a substitute husband and father,
Right.
but it's not a stepfather. So, but would a stepfather still be? Are they affected at all by this?
Well, I think you're thinking in terms of parental rights and
the man
responsibilities.
In a typical relationship, could be a man or a woman, married to the mother of the child, then that would be a step-parent situation where they're.
Right. I mean, I think what it is you have to look at, like, what is the basis?
It doesn't change that law.
No, it doesn't change any of that stuff. And I think what you're thinking of more is like parental rights and responsibilities. Yeah. And that's actually not addressed in this bill. This is just about the kind of the first step in the process, which is the person a legal parent? Therefore, they get rights and they also have responsibilities.
Whoever reports this bill should play at the time that this section comes up, Harper Valley PT.
So I'm going to keep going. So section 13C, which is on page 2 and line 13. And so that's amending 295. And this is just cleaning up some language and referring to the rules, getting rid of these references to these statutes that we repealed already. And then on page 3 of the amendment, section 13D, and that's an amendment to section 780. And that subsection 7 currently refers to 2 repealed laws. And so we just wanted to clean up that language and put in the new language that you'll see on lines 13 through 15. And then section 13A is kind of a counterpart to what is in the first instance of amendment, which is saying that if the gestational carrier agreement substantially meets the requirements that are all set forth in statute, then it's going to be enforceable. So it wouldn't be void if there was a small technical amendment.
So I'm going to invite the two witnesses to join us, and then if the committee has questions or they have points that they'd like to make, so we can hear from them.
Sure, and they're really fabulous at like the scenarios. I know Senator Hashim likes to give, well, this parent or a hypothetical or whatever, and they are the ones that are fabulous at puzzling all that out.
So Jessica and Polly, you want to join us by Zoom together? We'll take Jessica first for some statements and then Polly, but the questions may be answered by either one of you. Will that work?
Yes.
Great.
Well, thank you very much, Senators, for having me today. For the record, my name is Jessica Seaman. I'm the managing attorney for the Vermont Office of Child Support. And, you know, I will state right away that the Office of Child Support is in full agreement with the amendments to the Vermont Parentage Act and also the additional amendments that were taken from the miscellaneous judiciary bill with respect to cleaning up Title 15. We think this is the, as Michelle mentioned, you know, in 2018, the legislature passed the Parentage Act. That was a huge bill, a pretty significant piece of legislation. Vermont was one of the first states in the country to enact a law such as the Vermont Parentage Act. And I would say, you know, OCS lives and breathes with this act every day in the work that we do. And for the most part, things have been working really well. But we're here because there are a couple of changes that need to be made. And Michelle did a really good job, I think, of walking through the bill and sort of describing the little tweaks that we think need to be made to the law. So I don't really have any formal comments beyond that. I'm happy to answer any questions that the committee has. So thank you again for having me today.
Polly, do you have any opening comments?
Well, I'll just say so. Hi, my name is Polly Crozier. My pronouns are she, her. I'm the Director of Family Advocacy at GLBTQ Legal Advocates and Defenders. And I am a family lawyer by training. I had my own private practice for many years, and I serve on the National Enactment Committee of the Uniform Parentage Act, and I work really we do a lot of things at GLAAD, but my bread and butter is parentage legislation. I've worked in a number of states, every New England state, Michigan, on this type of legislation. And I was really privileged to work in support of Susan Murray and Kurt Hughes in their work on the Vermont Parentage Act in 2018, because my colleague, Mary Bonato, had worked on the version in Maine that the Vermont 2018 bill was based on Uniform Parentage Act and the Maine Parentage Act, and was really, as Jessica said, like so transformational. It was such a good law, and I think the process was so careful, like the study commission that really carefully looked at it and had all the stakeholders, and then the legislative process. And I just had this think, I think the 2018 law was really wonderful and really set New England on a good path. And has been really working well. And I just want to echo with Jessica that like GLAAD is in support of all of the, of the bill and of the amendments that you're hearing today. And I will just say, I think that the Vermont Parentage Act which really, secures the parentage relationship of children to their parents, has been so helpful and clarifying and made a tremendous difference. And I really see this bill and the amendments as tweaks, right? Of just like ironing out some of the spots that need to be ironed out. I think from the perspective of, I work closely with Kurt Hughes, who's a practitioner in Vermont, and we've been, seeing kind of some of the issues that have come up. And I think this amendment really resolves some of the ones that we have seen, which is we want to make sure that people without lawyers, pro se people, have access to justice, right? And to make sure that we're doing everything in the law we can to make sure they're getting their judgments in an easy way, they're getting them in a timely way, that we are making sure that it is easy for parents to establish that legal relationship, which is so key to children's stability. So I think that the tweaks really further those goals of access to justice and kind of consistency in courts throughout the state. And I think they're, very, straightforward and positive.
Thank you. I wonder if either one of you could give us some real life examples of how the 6-year-old law and how this changes might help certain families
Yeah.
or children. If you have any examples of how it's worked or, and
Yeah.
what problems you've seen.
Well, I'll just jump in and say, in terms of, so some of the changes to Article 7, right, to bring it kind of up to date with what we're seeing in parentage laws in other states and with the UPA. I think, one of the things that we're seeing in Vermont is that if you're a child, like, so let's say you're a lesbian couple and you're having a child through assisted reproduction, and, you've perhaps procured sperm from a sperm bank, and you just need a court judgment to confirm your parentage, make sure your child is secured no matter what state they go to, that the Vermont Parentage Act is really supposed to allow those people to go to court before birth and have a straightforward process to get a parentage judgment. And what we're finding in this, again, this particular piece mostly comes from Attorney Hughes, is that if they don't have a lawyer, it is very hard. They have a longer process, right? And so this is to say, like, to adding the line, for example, if people are in agreement and they come to the court shall act on that promptly. Like, often without a lawyer, there's kind of no, I understand, kind of impetus or kind of push forward. And so we want to make it very clear to the courts that when folks are in agreement and they're coming for this parentage judgment, we want you to act quickly to get them that judgment that they need. So that's one example of just trying to add in some pieces that make that process quicker and faster for pro se litigants. I'll pass it off to Jessica for any examples she might want to add.
Sure. So,
Go ahead. No.
okay. Sorry. Thank you. It's hard being on Zoom sometimes. So I would say that, having practiced in the child support arena prior to the enactment of the VPA, our old law really made it very easy for someone to challenge parentage through genetic testing. And in fact, our old law, there really was no mechanism to object to genetic testing if a party asked for it, objecting based on it not being in the best interest of the child, for example. And so, one thing that we've seen, because one thing that OCS does is we do a lot of genetic testing, and sometimes people apply for our services for that very reason. What we're finding now is that there's a more thoughtful analysis by the courts about whether or not genetic testing is in the best interest of the child. And in fact, the Parentage Act requires the court to go through that analysis. So we're seeing a real shift from, having these parentage proceedings, which often involve pro se litigants, where, the hearing is, I want genetic testing. Okay, we're going to order it. To, is that really in the best interest of the child? What is your relationship with that child? So from our perspective, I think the law has really allowed the court to consider the best interests of the child when adjudicating parentage. And in some cases, that has led to the adjudication of a child having more than two parents. And, we don't, OCS doesn't really see a lot of cases that involve ART or gestational carrier agreements, but we certainly see cases where a de facto parentage order has issued, and so we have three parents. And it makes it more complicated, but at the end of the day, I think it is creating stability for children and allowing the court to consider that as the primary interest in a parentage proceeding.
How's the access to the courts? With the delays that we've seen in all areas, are parents able to get access to the courts, or is this a long period for them?
I think I can answer that question. I would say that with respect to the kinds of filings that we see, divorces, parentage filings, we don't do a lot of work in the probate division, which is where I think some of the orders that issue as a result of a gestational carrier agreement or an ART agreement would issue. The court is accepting those filings promptly. The time, however, between filing a complaint and getting a hearing set or a case manager conference does vary from county to county, I think, based on a host of factors, including court staff and volume of cases. But, from our perspective, and, Polly alluded to this before, if we are able to have conversations with the parties before a case and try to solidify agreements with respect to parentage and or child support, we file those agreements, and usually the court is fairly quick at acting on stipulations. So as much as we're able to do that, we try. I don't think that we see the same delays that you're seeing in the criminal division, for example.
Other questions for Jessica or Paul? Ready to vote?
I mean, it feels pretty straightforward to me. I mean, not actually, but now that it's been explained, it seems quite
Well,
straightforward.
I think the way it's presented.
Yes.
I don't know that we need any other witnesses.
I don't think so.
I mean, the only other witness was Kurt Hughes, who you may remember from years past, because
Yeah.
he's been a practitioner in Vermont forever, and he was really involved, but he's in support. He's been, I mean, with Kurt and Jess and Polly, I will just say, because as you know, I do 100 different topics, so I'm not an expert necessarily in any of them, and they have really helped vet this well, so.
So besides adding the amendment from the miscellaneous judiciary bill, which made no sense to have two separate bills on the same subject, is there any other amendments that anybody has that they feel should be done? If not, I guess I'd entertain a motion to report favorably. Page 745.
So moved.
Senator Mahowski has moved to report favorably S 745 as amended, which will be a new draft, but
No, the amendment is all good to go.
Yeah, but you have to add it to the bill, right?
No, your
So we're
amendment,
gonna offer it as an amendment on the floor.
yeah, because you're, it's not that long, so you don't need to strike all.
Okay.
And whoever is courageous enough to report this on the floor, I promise I will help, and I have a script and everything, so looking at
So
you.
that's good.
I could see.
So.
She ain't looking at me.
We'll wait a few seconds for Senator Brewer.
I mean, if this is something that's in your interest area, I'm happy to.
Let me yield to you by all means.
No, I really don't mind.
Not see, no.
No,
So to get his vote later.
All right, well, we can vote now on that. So all those, Senator, any further discussion, we'll discuss who's gonna report this gentleman. Could be an interesting report. I can't remember who did the 2018. I don't think I did. I think Alice or Jeanette did it.
Oh, I bet it was Alice.
Because we determined I wasn't here.
You weren't.
Right.
Okay, Ben, could you please call the roll?
Senator Norris,
Yes.
Senator Grabowski,
Yes.
Senator Shi,
Yes.
Senator Sears,
Yes.
and I will ask Senator Booth to begin then.
So given Michelle's offer of tremendous help, who would like to report this? All right,
If no one wants to.
I feel the same way. If no one wants to, I'm happy to do it.
I don't want to.
I don't care. You're willing to do it?
I'm willing to do it unless you want to flip a coin.
We can flip a coin.
I don't have a coin.
I don't know if this is how we're deciding this right now.
Oh, she got a coin? I was gonna, right here's a coin.
Oh, perfect.
Who's calling it?
Heads.
Try it again.
Heads
Heads?
means you choose.
Sure.
Please.
You got a
Yes.
choice?
Did you lose it?
Oh, yeah, I lost it.
Oh, it's tails. You get to choose.
Now I feel weird if I just pass it to you. I'll just report it. That's fine.
That was a waste of time.
It was, but it was entertaining, so that's,
It was
I'm happy to
entertaining.
report.
Hey, you got to report Proposition 4.
Yeah.
And talk about equal rights. Now it's time for you to talk about parental rights.
Right, and you're really interested in family law, right? And we
I
haven't
am.
done a lot of that
Yes.
this biennium, so.
Happy to report.
So I think that's terrific, that you're gonna do that in light of your support for equal rights.
Thanks.
I do believe the whole Senate supported equal rights.
I think they did, yes, but this is different.
I know.
These are parental rights.
Well, we want to clarify, it's not parental rights, it's are you
I
a legal
understand.
parent? Okay, sorry. Just because people do get confused, people will ask you questions about custody and all that stuff.
Well, you can explain the man in the house repeal.
Right.
Sure.
And I do have a summary for
That'd
everything,
be
so I'll
I
send that to
think
you.
that might be the most interesting to
Right.
find the history of that law. And how
Oh, right,
old
let me
it
see
is.
if I can,
I mean, I remember when we did a bill and we left it on the books that in bankruptcy, you cannot take the oath to oxen. a certain
I remember
number
that.
of chickens.
I saw that, yeah.
And we just said, heck, leave it on the books,
Yeah,
let
there's
the
some,
bankruptcy courts lead the ox.
leave the oxen. We have some weird laws that are still on the books. I find them every once in a while.
well, do you remember when we were getting ready to do civil unions, and the first thing I did was we went through all 33 titles to find every law that mentioned spouse, husband, wife, a marital relationship, and I think we found 1,063 laws, and there were some, it would be like,
We're gonna,
the cow, who the cow belongs
we're
to.
gonna take a break.
Were there
until
dowries?
10:15.